Now back to Inside Real Estate. Here's Mike the Realtor.
Hey folks, we're back. Inside Real Estate, Mike Kruziniga here. Website InsideRealEstateRadio.com, InsideRealEstateRadio.com. Hey, it's time for our Attorney at Law segment. We've got Perry Cockerell here live in studio. Perry, how's it going?
Hey, Mike, I am glad to be back.
Good to see you again. By the way, folks, the website is perryjcockerell.com, perryjcockerell.com. And, of course, not only is our resident legal expert, but he is also the author extraordinaire, author of A Private War, which we've talked about here on the show before. That book is available on Amazon.com, A Private War. And you've also got some book signings going on as well, right?
I did. Well, I had one in Fort Worth last month, and we plan to have another one in Dallas, so I'll get some information on that as soon as I know the date.
Great.
I enjoy doing that.
Yeah, absolutely. We'll put that on the website. And, of course, it's on yours as well. You've been busy. Also, you were down in San Antonio speaking at a conference down there as well. What was going on in San Antonio?
I did. I came back really refreshed from that seminar. That's the Advanced Real Estate Seminar that's put on every year by the State Bar of Texas. And I was asked to give a speech that I gave 6 months ago to the Texas Land Title Association. It was involving the home equity litigation, all the changes that were going on. And I've mentioned those in the prior
shows, right?
Here.
Yeah.
And the reason that was important is those cases were brought up, and many of the attorneys are not familiar with them because they're not, they're so new,
right, and
being tossed around. And there were many speakers, just 3 days. I didn't stay for the entire seminar, but I got to speak. And when you get to speak, you spend a lot of time putting those together, and PowerPoint briefing. There's a lot of attorneys there, 500 at least, and a lot of people get some real benefit from those 2 large courses, volumes of many, many papers, and it really is a good thing for the attorneys. They get all the latest cases. CLE is required. Mm-hmm. All attorneys participate when they do. Then they get their annual continuing legal education seminar credits for that. I went through, and I'll just go briefly, the biggest cases that came out is, as you know, there was this statute limitation issue that had been going on for years as to whether violations of these home equity loans could be raised more than 4 years after the contracts were entered into, and now we know that they can. So as long as a home equity loan is in effect, and then there's some type of violation, the borrower needs to give notice to the lender to cure that violation. The lender can cure within 60 days, and there's many things that the lender can do to cure those. Not very many loans are forfeited like they were, because of these violations, because there's many ways that lenders can cure these potential problems.
Right.
And, of course, that was the Wood decision that came out in May. I also want to mention my paper was due May 23, and I was going to use the previous one I gave 6 months ago where there's a 4-year statute of limitation, et cetera, and then the law changed on May 20th, and it changed everything. I had to work the entire weekend to get that together. They gave me a 2-week extension, and you just would not believe how many cases have been effectively overruled as a result of that new decision from the Texas Supreme Court. And there are many federal cases from federal courts construing Texas law that are now in error.
Right.
And there's several bankruptcy decisions that are in error now, rendered several years ago now, that are just based on the wrong law or reasoning.
It's really opened up a whole can of worms, really.
It really has. And
let's, and for the people out there, let's just kind of recap, and I know we talked about this in the other shows, but let's quickly recap the highlights of the law and then what has changed for them real quick.
Okay, for years, if a loan was closed and 4 years went by, regardless of if there was an error in that loan, regardless of what it was, the borrower couldn't challenge that more than 4 years later.
4-year statute of limitations.
They essentially waived, and it was a case from the Fifth Circuit from New Orleans, which is a federal appeals court. Now, that seemed like a good rule for lenders and title insurance companies, but over time it became attacked by many in industry, or not the industry, but by borrowers groups, people representing debtors, because of some very unusual cases. One was where a woman did not sign the home equity loan.
Mm-hmm.
She didn't realize that 4 years go by and she's bound by it. They said, well, you knew about it and you didn't do anything about it. 4-year statute of limitation. Now there's one in the Texas Supreme Court now where a wife's signature was forged. Court said, well, you knew about it. 4 years went by and you didn't file suit. Too bad. Now they're examining. They may take that one up because in that case, the wife signed a warranty deed and transferred that property. You really can't ratify a forgery, but you can if you file a deed later.
Mm-hmm.
There was a case involved a second home equity lend. We know you can't have a second home equity loan on a home. The court said, no, that's barred by the 4-year statute of limitation. So, and there were other types of violations that you just clearly can't have, but you could have because they could be validated because the borrower didn't move anything within 4 years to invalidate.
And look, so the thing is like, let's say you get a mortgage on a property or you're refinancing, whatever the case may be, these are generally long-term agreements with the lender. They're, generally a 15, 20, 25, 30 year. There's even some 40-year mortgages out there as well. Time will tell as when there's going to be an issue. And generally that issue occurs, at divorce time. And so that's beyond that 4-year statute of limitations. That's kind of why these issues were arising past the 4 years.
That's right.
Right.
2 of the big cases are divorce cases.
Yeah.
Now, so the Supreme Court straightened all this out and said, no, if a loan has to comply with the Texas Constitution or it's not valid. But the lender can cure that within 60 days. Now, that can occur all during the time of the loan, which may be more than 4 years later. There is no statute of limitation. So, in essence, the Supreme Court balanced the case, balanced it so that it addresses the lender and the borrower's concerns. Now, that can also have some other consequences, too. On the same day, the court issued a case called Garofolo, and that's where a borrower had completely paid off a loan. Totally. And the lender had filed a release of lien of record. But the Constitution says that the lender should send that release of lien to the borrower. The borrower filed suit and said, well, I sent you notice. You didn't send me the release of lien within 60 days. You forfeit the loan. Give me all my money back. Supreme Court says no to that, although that's exactly what the Texas Constitution says.
But by law, that's what it said, right?
That's what it says. Now, they say no.
But they're not going to set that precedent.
They're just not going to do that. They say that, no, the 6 mechanisms to cure this loan can't cure this problem because you can't refinance, you can't give them $1,000, you can't do anything under the Constitution to fix the problem. And what's the problem? Return a release of lien, which was filed of record anyway. We're sorry we didn't. So the forfeiture enforcement mechanism is tied to enforcement of the note. So if you're trying to enforce that note, you have a loan that doesn't comply and you fail to comply, you could forfeit that loan. But here that loan was paid off. The lender was not trying to forfeit, wasn't trying to do anything. It's not subject to forfeiture in that case. That's a breach of contract suit. So those are kind of cases that completely now have, I would say, balanced out the home equity litigation. Attorneys are learning those are really recent, so I like that.
In that case, is the borrower, if he brought suit, is he going to get anything out of that? Is he just spinning wheels?
Probably, because you could imagine that was a federal case. They went to federal court, Fifth Circuit in New Orleans. Fifth Circuit sent it by what they call certified question to ask the Supreme Court, what's the law of Texas in a case like this? So the best that that borrower could get maybe would be legal fees or something. I'm not even sure what will happen because that case is still in litigation. Right. It was just sent back with this. This is the answer.
Interesting.
So the other is,
okay.
I don't know if we have any
time No, we got some time. Moving on.
I want to give credit to one of the speakers. His name was Michael Luxinger. He wrote a really good paper on it. And I'll move over to a transactional type issue now and move away from the home equity litigation. Because some of the attorneys who are practicing estates in Texas will always, recommend a properly drafted will to transfer property, and they will agree and recommend that the probate process is fairly straightforward, it's uncomplicated, and it has many benefits. So a Texas attorney will recommend that and it's a good idea to have a will and let property transfer that way.
Of course. The
Texas legislature makes the law and the policy in this state, and they have simply stepped in and have created what is called a transfer of death deed. which is really not a deed. I mean, it is a deed, but it reads a little bit differently than a deed. But and it's to answer a need that a lot of people have. They don't have any resources. They have nothing else to convey. They don't need an attorney. They don't want a will. They don't want to go through the complications of transferring real estate. And they're very familiar with what it takes to have a beneficiary on a deposit account, on a bank account, a brokerage account. They understand life insurance policies. They understand retirement accounts. And they wonder, okay, why can't we just transfer our home this way? Why do we have to go through the complicated will, probating the will, filing it, and all of that, and paying an attorney? And the legislature has finally said yes to that. And they created what is Chapter 114 of the Texas Estates Code, called the Transfer on Death Deed. Some people call it TOD. And it doesn't use the same terms. It uses transferor, owner, beneficiary. It's not in the Texas Property Code where the other property conveyances are contained. It's in the Texas Estates Code, and it's after the particular statutes that deal with survivorship agreements, payable on death accounts. So it's treated in the same way. So it's a very simple document, very easy to understand, written for anyone. So I compliment the legislature on creating a document like that. Quite the contrary, if you read the home equity provisions of the Constitution, which are labor thin and nobody understands them, but they did a really good job in this case. Well, anyway, if this particular deed, which has a form, has the essential elements such as the property description, you have to have that. The name of the transfer has to be signed. It has to be acknowledged before a notary, and it has to be filed in the county where the property is located. Then that document will transfer that property upon death. It's not effective. It's until death of the owner. Some other aspects of it is that it can be revoked. It's effective without notice or consent by the beneficiary. And it can't be created by a power of attorney. So in other words, some person couldn't create a power of attorney and create that and transfer somebody's homestead away from them.
Of course.
And the owner can revoke it by just filing a revocation of record, or they can create another type of instrument like that. And if they happen to do a will on top of that, that will is not going to override this deed, which is already recorded of record. And there's a number of other provisions that are in the statute about that, but I thought people might want to know about that. They might want to go contact an attorney if they want, or they could check the statute.
Yeah, absolutely.
itself.
Yeah, I mean, it is so complicated, when someone does pass away with the passing of real estate. And so this is huge. And it's another way to do it. There's also, like we've kind of talked about before the show, the Lady Bird deed, which is not the technical term, of course, but after Lady Bird Johnson, because LBJ left a piece of property to her in this particular manner, and so they called it that.
I've read that it wasn't after her, but is that true?
I've read what you read. There was contradictory, but I saw that, and that's why supposedly it was called that way. But it was a piece of property that he had left to her. But the deed, the point of this, and I've done this with another client, and it was an elderly couple, and they purchased a piece of property with their son and the daughter-in-law, and so all four names were on the deed, but the kids couldn't do anything with the property. They couldn't mortgage it and couldn't sell it or anything like that, so long as the parents were alive. And as the parents, passed away, once both parents passed away, full ownership just belonged to the kids, and so there was no need for probating that piece of property, which was good for them.
No, I think you're right on. I was thinking of another type of deed. It was called the enhanced revocable life estate deed, which had nothing to do with the Lady Bird deed, is what you were talking. But this is something that was. I pulled this out of many topics from that, which I gave you the brochure showing that, and I thought it might be a simple one to bring up this morning. Check into it. I know I have instances of insolvent estates, people with no money, and they want a way to do this.
Yeah, absolutely. Yeah, good stuff. Good stuff from Perry Cockerell, our resident attorney expert. By the way, his website, perryjcockerell.com. You can connect with him about legal questions. Look, their firm handles all kinds of things, both corporate, personal. So go to Perry's website, perryjcockerell.com. And, of course, if you want to take a peek at his book, it's available on Amazon.com, A Private War. This is a great World War II era book. Highly recommended, great read, and go to his website first, and then you can find it over on Amazon.
I'm already working on the sequel.
You are?
I have no time. When I'm sleeping, I'm working on the sequel. I figure out how to do it. But the black reporters who are in that I highlight, I'm going to continue their work in this fictional newspaper in Birmingham, and they're going to follow on and continue doing stories. And so I look forward to that. Maybe in a year we get a sequel to come out.
Get the next one out. Very good. Author of Private War, Perry Cockerell, right here on Inside Real Estate Radio, folks. Hey, the website, InsideRealEstateRadio.com, InsideRealEstateRadio.com for all of your real estate needs. And then, of course, you can connect with Perry for legal needs. You can connect with Richard for all your insurance needs and mortgage refinance. You can connect with Terry. And, hey, folks, we are here every single Sunday, 8 to 9 a.m. And don't forget, I'm here for your real estate needs, too. If you want to sell some real estate or you want to buy some real estate, hey, I am here, Mike the Realtor. Give me a shout. Hey, folks, Inside Real Estate. See you next week. We're out.